Good evening, friends. They say for a lawyer, one of the biggest interplay is the legal drafting. That creates the impression before a judge or a party before he actually acknowledges as to what are the further communications. So it is a facet of the communication, the legal, the effective legal drafting, which are the skills that actually matters, is a session which Dr. Vidya Selvamony has agreed with us to make us understand the nitty-gritties of the same. We are glad that she has accepted our invite. Over to you, ma'am, and thank you for accepting our invite.
Thank you, sir. Good evening to all of you. So, as Sir told, I will be dealing today with the topic of drafting in different perspectives and why drafting is important and what all are the best important qualities which we have to keep in mind while we are drafting. So, to start with, one of the important aspects, what is the meaning of drafting? So, drafting is a process of creating a preliminary or a rough draft. That is the first important aspect of a document. It can be a technical paper or drawings, anything before finalizing. At what is important for that? It is important that we organize certain ideas, structures, and in the legal context. And before even we start, there are many aspects that people will come and tell us. So we need to take what is important from that and we need to see how do we put it, convert what is orally stated into a format of draft and to see what all the information what they tell. It's not that everything is required, or sometimes they might, whoever the person is talking to us, a client for example, will talk to us in very abstract manner with no connections. They will tell today this happened, a year back something happened, previously something happened. So it is the duty of whoever is drafting to collect the information or gather the information in a very chronological order, or to see that there is a flow of information. And the next important aspect what we need to do is we need to understand for what are we doing this particular draft. Always ask these questions: for what we are doing, for whom we are doing, how we are doing to do, and when we are doing this particular aspect. So according to each situations, it keeps changing. The drafting patterns and the qualities of drafting also keeps changing. So when we talk about with these, we will move on. So what are kind of draftings? Draftings are nothing but written compositions, like creating initial version of text, ideas, putting it down without excessive concerns for perfection. Don't see perfection in the first initial thing. Then legal drafting is the next type of drafting, which is preparation of legally binding documents such as contracts, wills. So to divide that, you can divide it into pleadings and conveyancing. Pleadings, which we will move on later, which is explained under the Civil Procedure Code, and conveyancing, which includes all the particulars with regard to transfer of property acts and various other successions and everything. And the next important part of drafting is also technical drawings, engineerings, like creation of plans, diagrams, sketches for buildings. All this also we can tell that as draftings. And then what are the key techniques which are required is one, first important is preparing. How do we prepare a draft? So we have to number of sittings, follow brainstormings, but we have to keep editing. There is never a draft gets final. So we have to keep improvising, putting in more and more and more structured information as and when we get. And then the next one is you have to structure. So that which means we have to establish the layout and the main contents of what we are drafting. So for that, we should have clarity even before we start drafting. That is why we ask those questions. Why are we doing it and for whom are we doing? Who are our audience, like stakeholder, whether it is court or it is any other else. So we need to understand that, and based on that, the structure also follows. And the third one is preciseness, and then the tools. Nowadays, we have many tools which we also can use for drafting. And then the next important aspect is when we specifically talk about legal drafting, drafting is very critical aspect, and it needs to have an organizing ideas. It should clearly organize your ideas, what you want to tell orally, which you want to, now you can't tell everything orally. So we are putting it in a very systematic manner, and it should be structured well, and it should have the redefined context. There's no missing links, which means it should be structured, and the organization of the draft should be very good. Drafting, because that helps us to understand the complex information in a logical, effective manner. And next, it should be we should have clarity, and it should be very precise, because when you are clarity is always think it is not for me who I'm drafting. The drafting is for a third party who will read this draft, might be tomorrow, might be after a month, after a few years. Especially when we are drafting legal documents, it might be many years, 5 years, 6 years, when the judge is going to pass a judgment. That is where he will read the entire pleadings once again. So whether if what I meant today is also applicable after few years. So for that, we have to be very careful that it has to be very clear, and it should be having very simple language, no ambiguity, and then lot of feedbacks. That's why I told the drafts never get finalized in the first instance. We draft, then we send it back to the parties, where the parties would have told, oh, this certain things are missing. Then we add it, and then again. So it has up and downs. Number of times feedbacks are taken, inputs are taken, comments are incorporated, and only then we try to systematically put it. So when you think, okay, my draft is finalized and my draft is coming to a shape, then important, we need to start putting in legal points, and also in many places we are need to put about no controversy statements, no ambiguities in our draft should be there, and errors in drafting. And most importantly, when we are telling systematic drafting, one, chronology of events are very necessary. The chronology can be decided by each individual who is drafting. The patterns can change, but chronology is very important. Some people write it date-wise. Some of us write it event-wise. After this event, this happened, each event-wise. Some of them write it facts-wise. So the pattern of drafting can change, but however, the structuring pattern is very important, because with a small structure also, when a drafting is not, when the information what we are trying to convey to the other person is not very clear, then the entire thing can go against us, or it might also many times it will not come in the way I constituted that particular pleadings. When the reader is reading it, it is always in some other format. So for us, it is very important that the reader reads number of documents, number of facts. It is similar facts most of the time. So they should not get confused, or there should not be any ambiguity. That is why structuring is very important. Structuring is individual choices, but however, it is very important. And then the effective for what are the requirements for effective legal drafting? For effective legal drafting, the first important requirements, it should be precise. We should have clarity in what we are writing. We should not write something which is not there in the law, or which is against the law. And then adhering to the key important principle that is called as KISS principles, which is keep it simple, short, and sweet. So, so that we are not trying to fill pages. What we want, we are keeping it in a very precise manner. And then to mean these, the KISS principles are used mostly to minimize the risk and to maximize clients' rights. And this well-structured document, that can be notice, contract, any pleadings or whatever, always we need to use active voices and define the key terms, and avoid legal terms too much, and also ensure that the person who is reading is understanding the way we are putting it. And also, the other important factor is our drafting should not call for more and more litigations or more and more disputes. Our drafting should be in such a way that we are preventing any future disputes, so that this drafting is so clear that because of this, there is no future disputes which can arise at all. So what are the key principles in effective legal drafting is, the first principle is clarity and simplicity. So avoid legalizing, avoid lot of jargons which we are using. Use plain language to ensure even a lay person can understand the document. So that is the clarity and simplicity concept. Use it, write anything what you write in a language which you are clear, which we understand that, okay, this is what I'm meaning. This is what the audience, when the reading also will understand in the same pattern, how I am telling. So write it in that same plain language, and to ensure that the understanding of the document, you and the person who is going to read has the same level of understanding. That's the first important key principle. The second one is it should be precise. So use fewer languages, effective words to define legal relationships, rights, and obligations. So these we need not complicate the scenario. Like, for example, if you're drafting a partition suit and we want to talk about 3 generations of how the family tree we want to establish, we need not complicate. We can also put it very clearly in one drawing, and we can tell grandfather, grandmother, for them how many children, for each of them how many children. And so it's a very clear form of, even in legal documents, we can draft it, put in charts to establish and show the family tree or geological tree, whichever is that we can also show that in a very precise manner. Sometimes instead of doing that, we try to tell most of the time, the thing is, my grandfather's name is also the grandson's name. So the grandson's name will be the other son's name. So there'll be, with one name, there are lots and lots of confusions. So when we are trying to address one person with the same name, so we need to keep telling that, no, I am trying to address the grandson, which the name of the grandfather is also same, the name of the great grandfather is also same. So that will only create a lot of confusions in the mind of the person who is going to read it, or the person who is going to hear what we are trying to explain. So that is why we have to be very precise and establish that in a very systematic way, so that if any confusion, we can just see that chart and, okay, this is what the person they're representing, or this is what the person they're asking for this particular relief, or what that can be immediately cross-checked. So that is also very important. Then the next important aspect is use always active voices. Use active voice. What does it mean? Is instead of passive voice, to clarify who is responsible for each action. Like, for example, we'll tell, let the buyer shall pay for this particular aspect. So use always active voices, that so that there is again no confusion. And then consistency. So maintain consistency, terminology, definitions, formatting throughout the document to avoid any ambiguity. And then one of the other important thing is structuring of your document. Organize documents logically with clear headings, definitions, and numbering sections. So these are also very important for your effective legal drafting. Then steps, what is required is gather information. And while gathering information, we also need to do some research for this particular purpose. So understanding the purpose, the parties involved, and applicable laws before drafting. So for any particular drafting, it is important that we also know the law on that particular subject of what we are drafting. So that's why the client layman will not know the legal, which law is applicable. So that is the duty of an advocate, to gather information, do a little bit of research, whether there are certain judgments on this particular, where there's law of precedence already established in particular aspects. So that gathering information from client's side, researchers of advocates. So both together, so we have to understand the purpose, then who are the parties involved, and then applicable laws which are applicable for this particular context and for this relief. These are the laws which are applicable, that we need to be very clear even before drafting. Then the second important step is outline. Create a structure that outlines all key points. See, we tell write facts of the case. So even facts of the case can be structured very well. So prepare that outline very clearly. The third one is focus on covering all essential elements, including your liabilities, rights, or whatever you want to tell. Focus on all essential elements. Don't miss out on any essential element in your first draft. Don't go into number of pages. Oh, I'm exceeding number of pages, I'm exceeding number of, there's no limitation with pages and words while we are drafting. As much as required information, keep putting law, you keep putting into that. Later, second draft, third draft, we can finalize and make it in a very what is required we can keep, and what is not required we can keep it as a research, which we can use it later for arguments or for any other time of evidence, cross examination, or anything we can use. So it's important that focus on all the essential elements of drafting. Don't miss out on any information while you're doing your first initial drafts. Then you review and edit your drafts for checking for all grammatical errors, then accuracies, whether it is accurate, whether I'm giving correct information, whether the dates, cross check the dates, the places where we are telling this happened, that happened. So accuracy, so that there's no overlapping of information, there is no any other part of information which there's nothing which is the flow is going very clearly. Then ideally, which what it means is the reading the document allowed to identify any anything which is confusing, or whether the para is not complete or the sentence is not complete. All this we need to review and edit our particular documents. Then the next important aspect is refine our draft. That the refine our draft is the last important aspect, which is very essential for us to refine and come into a particular structured. Now we have put lot of things. We are trying to remove, add, putting it in a very structured pattern. So when last one important thing is we are refining our document. So ensure that all the documents is tailored specifically to the case, and then avoid over reliance on templates. See, when if the minute we want any draft nowadays, we need not even search or old drafts and things. The minute we can give it in Google, or now we have Chat GPT and things, we can just give draft a plain for me. So it's important as a legal professional, we can't rely on templates. We can use it for structuring or documents, but sometimes it gives what it wants. However, we give prompt words, however we try to give what I want, you draft accordingly. Some people scold the systems and things like that. Even whatever we do, it is always important we read it out clearly number of times, and then we refine that finally, so that we don't rely on all these softwares or any other technologies. And what we need to avoid when we are drafting a legal document, the important aspect what we need to keep in mind is we need to avoid vague language which can lead to misinterpretation. Now what do we mean by vague languages? That creates ambiguity. Any words which create ambiguity, we need to avoid. And then we need to do unnecessary words which dilutes the strength of the documents. We whatever words we know, everything we need not put. So it is important we don't use words which are not required in that particular document. And then, as I told you, always use passive voice. That can don't use always use active voice. Don't use passive voice, because passive voice can create confusion regarding the subject and its responsibilities. So these are few essential effective legal drafting what we need to keep in mind. The next important thing is for what we should avoid when we are doing legal drafting. What we need to do, as I told, first gather all the information, put it as how they have told, then try to fill in gaps, then bring in chronology of events one after one after one. The chronology can be your pattern of date wise, structuring wise, information wise, facts wise, however, and then read it out loudly to see that where any information missing. If I put this, will it create confusion to the reader? So will the reader have a question there to see, check other documents to get clarification? Or can I clarify that to the reader in here itself without even going to check, oh, for this, whether documents are existing or whether anything is there? Without even that, can I clear that particular doubt in my draft itself? So that is also very important aspects. So, but what do you need to avoid when you're drafting a legal document is, the first important aspect is as I told you, ambiguity, excessive, don't use unnecessary words, and then don't use too much legal words which we ourselves don't know. Don't use a lot of Latin words which if I put a lot of Latin words and legal words might be that impress. It's nothing like that. You can draft in your simple language with the language we know. We can draft very beautifully. So it is not that we need to search for all the legal terminologies and put it in our draft. So don't, and without, we don't know in what context it is we are using it. So don't use those particular words. And then double negatives, don't use, don't be vague. And then always use plain language, direct language, define terms and logical structures. And then the next important aspect is don't, there is one say which they always tells, lawyers don't know how to put full stop, comma, or inverted quotes and all those. Because our drafts, when we start, we end it in a so big draft, one paragraph, we keep it so big and with no full stop, with no quotes, nothing, with no commas. So to avoid that, always when we are drafting, where we take a breath or where I can only read so much, please pause it there, keep a full stop there. So the long sentences, it's not that I need to tell everything in one sentence or one paragraph. You can also make the long sentences short, 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 and remove the complicities and make it short and precise. Then inconsistencies, terminologies don't use double negatives, like for example which avoid complex phrasings, like for just examples are not unintended. Unintended itself is meaning that I'm not intending, but again what we use for that, not unintended, so that's, so avoid that phrases. Like then we write as not insignificant. Insignificant itself means it is not significant, there we write not insignificant. So how do you, that will that not create confusions in that particular phrase which we are reading? So it's also important that avoid double negatives. And formatting is also very important. Avoid disorganizing, poorly numbered, unformatted text, and make negative difficult, and make the navigation of the reader very difficult. Don't make that. Then what are you need to do for a structured and understanding that this error I should not do is, first important thing is we need to link the gaps, missing considerations. What is missing in this? We need to touch so that one point is linked to other point, and then there is continuity in reading. And then always don't forget anything with related to legal rights. When you have any legal points like IP rights, confidentiality clause or something, it's important we inbuilt that in our document. And then it's also important to proofread our document number of times. See, many times the common mistake is we do not have time to read 3 to 4 times, or we don't have one time I draft, I one second time when I read, I can't make out mistake because I only drafted. Or the third important thing is because I drafted, my mind is going into, my mind is reading something, what is there in paper is something. So these things, to avoid that, it's always important to, we need to proofread a document. Might be there'll be typo errors, there'll be wrong dates or incorrect cross references, number of things we can do, that these are human errors at any age, any person can do. So it is always important we proofread our documents at least 2 times before even going into the court, or for we are doing, it's going for any registrations or anything, it's very important. So the common legal drafting mistakes to avoid is, first, failure to defining major terms. And then use a consistent language. Don't use different languages up and down. The language terminologies, keep it correct. And then we need to structure it well. And then including unnecessary information is not required. What is required you take, what is not required you don't take. It is not that whatever I have I need to put, but however I've told in the first draft put everything, in the second draft remove, you think okay this is already told in different ways, so remove it. In the third draft, you can make it even more simple. If your first draft is 50 pages, second draft can be 20 pages, your third draft can be 6 pages. So that's the level of proofreading and editing your drafts. So the common mistakes to avoid. And now moving on to the legal drafting, especially legal drafting. So drafting is explained to us under the Order 6 of Civil Procedure Code 1908, which talks very clearly, talks about creating precise, structured and concise legal documents. And according to drafting, it tells plains and written statements containing only material facts, not evidences. So the key requirements of drafting a legal document, it is adhere to Order 6 and Order 7, which talks about various other factors, which we will talk now. Now, what are the key principles and rules of drafting, which is explained to us under Order 6? Pleading must state only material facts. We need not plead any evidences, or we need not plead even law. That is what the very clearly Order 6 talks about. And then Order 7 talks about what is a plaint. So plaint, what all it must contain. Plaint is also a written statement, or it's a statement of the person who is approaching the court. This particular person the aggrieved party try to tell what has made me aggrieved and what is wrong in something. So I'm seeking a legal relief. But however, very important while you're drafting a plaint is the most important thing is always go to the correct jurisdiction. That is before which court we will go and we are which before which court we are going to seek that particular relief. So does that court have the power, which means the jurisdiction to grant what I am asking? So the first line should match with the last prayer, what I'm going to ask. The first line is before which court I'm going and whether that court has the power to grant me that prayer, the relief, what I'm going to ask. And then structure your plaint before even drafting into 6 important parts. What are the 6 important parts? The first important part, divide it as cause title. Because if your cause title is wrong, then your entire pleadings, what you're drafting, there will be a lot of mistakes, because if the position of parties are wrong, or I'm talking about something and some party is not at all covered in the cause title. So I am representing plaintiff and I'm writing everything about someone defendant or something. So you can avoid. So first important aspect when you are drafting a plaint, this is for our own learning process. Divide it into 6 important parts. The first part is the cause title. Second part is always every legal document have a heading under which provision of law you are coming before the court. So heading. And the third part of your drafting a plaint is you have facts of the case. So the facts of the case, whatever the plaintiff want to submit, that can be done. And the fourth important aspect is the mandatory clauses that we normally forget when we are drafting in continuation. We forget the mandatory clauses, and then we go into relief, what I want. That's the fifth important thing. And the sixth is the verification of the parties, the pleadings, whoever is for whom we, the advocates, are drafting the pleadings, they are the client or the parties are verifying this. So always divide this into 6 parts so that we do not miss out on any of this when we are drafting. So while going to the first part, what is very important is the pleader, the cause title. So in the cause title, as I told you, the first line is before which court we are going and at which place we are going to the court. So that's very important. Then the type of case which we are filing, whether it is an original suit, whether it's criminal miscellaneous, whether it's a matrimonial case or what. This also identify with your first 2 above lines. Okay, whether this particular relief can be given by this particular court. So the type of the case is very important. And then between which parties. So between which parties we need to get about the information, the plaintiff, who is the plaintiff. If you have one plaintiff, or we need to make others also plaintiff for this particular relief, what I'm asking. So between the person who is going to the court is called as plaintiff, and against whom we are going is called as defendant in civil courts in part of pleadings. But this position keeps changing it according to the each court and what we are asking for. So this much information is compulsory and it is necessary when the to cover the first aspect of cause title. And when you're writing between, also we need to write about the name of the parties. We need to write the age of the parties. We need to write the son, daughter, or whatever of that particular party. And then we need to write the full residential address. If you have phone number of party, please put the phone number of the parties. To serve notices and things, that becomes easier. So all this, so for how many of our plaintiffs you have, put all this information. If the plaintiffs are residing the same address, then make 1, 2, 3, 4, and then put common address for the plaintiffs. But however, give numbers to each plaintiff. If there are only one plaintiff, perfectly fine, plaintiff. If you have more than one plaintiff, we don't write plaintiff generally. Please put plaintiff number 1, plaintiff number 2. So give identification to the parties as well. That is also very important. Then write similar pattern for defendants. Defendant's name, aged about, we might not know. So that's why we put aged about, because we don't know exactly what is the age. And then daughter and son of, if you know, right? Otherwise, leave that point, because if you don't know the defendant's father's name or mother's name, it's perfectly fine. And then write the full address where the notices and things have to go, and all those full details. Similarly, if you have one defendant, you put defendant. If you have number of defendants, give each defendant an identification. Put defendant number 1, 2, 3, 4, so that you are very clear of which defendant we are addressing. This our particular each defendant have different roles. So that is very important. So after this is in toto called as cause title. So first point is over. The second is always, as I told you, in any legal document, heading is there. So if you're drafting a plaint, you write memorandum of plaint submitted under, filed by the plaintiff under Order 7, Rule 1, or whichever relief, under read with Section 26 of Civil Procedure Code. So this heading is not static in pleadings. It keeps changing. If I'm filing a written statement, it changes. If I'm filing an interlocutory application, it changes. So it keeps changing that heading, but heading is there. So for everything, that heading is very important. That's why I told you when you are dividing into 6 parts, second important part is heading. The third important part is facts of the case. So till now, whatever I was explaining to you about what we need to keep in mind while we are drafting. So all those we need to keep, and we need to draft. The plaintiff submits whatever the client is told. This is what the client is telling, and that in a very structured manner, one after one, and with no ambiguity, no vagueness, with no negative languages or nothing. Very in simple language, facts of the case. But remember, each facts of the case, please give numbering. 1, 2, 3, 4, 5. We need to number the facts in an order. So after we finish narrating the facts, it's important that there is few mandatory clauses which we need to put. Like for example, juris, cause of action. When did the actual cause arise? Is there a problem? Did it come today, or it happened few days back and I am coming to the court little late? So it's important we inform the court that when the cause of action arose. So that we need to write. Then we need to write about limitation. Limitation is covered under the Limitation Act. But however, we need to write that whether the plaintiff has come to the court within the period of limitation as explained in the Limitation Act, or I've come late. If I've come late, then what I need to do to get relief of overcoming, condoning my delay, that we need to do. So whether I've come to the court well within time. So the cause of action is important, limitation is important. Then for every case, we need to pay court fees. Whether we have calculated the court fees according to the Court Fees and Suit Valuation Act, have we calculated the fees correctly, and have we paid the fees? That also we need to see. And many times we write 25 with, we don't even know for which relief we are asking. So it's important we also cross-check that and to see whether we have paid correct court fees. And then the next important thing is jurisdiction of the court. So whether I have come to the correct court, which has the power to give me the relief what I have asked. So that is also very important. Otherwise, we keep fighting our case for a number of years, and then we try to understand that, oh, this court don't even have jurisdiction. So what happens? It is a waste of time, the client's time, our money, every money, client's money, court's time, most important, then efforts which we have put in, everything will go waste. So important, the thing is, find out whether this court has a jurisdiction to give the relief what I have asked. So these first one is cause of action, and your mandatory clauses is must. Without that, it is your pleadings are not complete. Second, jurisdiction. Third, limitation. Fourth, your court fees valuation you need to do. And we also need to see if we have an alternative remedy, then we can go to that particular alternative remedy and we can go and ask. So I'm coming to you because I don't have any other alternative remedy. So that also we need to plead in our pleadings. And then we also need to tell, in case I have already filed against this particular party, if any other suit or any writ is pending, it is important we inform in this particular pleadings that I've already filed a petition for some other relief. Now I'm filing for declaration. This is just an example. I've already filed an injunction suit which is pending before that particular court. But that is the stage, the case of the stage is something different. But now I'm seeking a relief of declaration and I'm filing. So it's important we inform the court if there is in your knowledge that you are aware that there was already an existing case which I have filed and which is pending before the court. It's important we explain that and we tell that to the court. So these are something called as mandatory clauses without which your pleadings are incomplete. So it's important you put this clause. Why I'm telling incomplete, if you do not plead these, it can also be a reason for asking for rejection of your plaint, which is explained under Order 7 Rule 11 as well. So it's important without even going into that, we ourselves plead all this. So your first part, as told, cause title is over, heading is over, facts of the case, narrate it very clearly. Then the fourth one was mandatory clauses. So once you finish all this, then your fifth important part is, what is the relief I am asking? Prayer. What all in one pleadings? Don't go more than one prayer. If your subject matter is one, please ask only one relief. Don't ask multiple reliefs, which the court will not grant. So ask one. So for all these, what is the relief you're asking? Prayer. And always ask, don't demand the court. Please ask for wherefore. We humbly pray. We are praying that the Honorable Court may please be pleased to be grant this particular relief to us, and ask what you want, and ask it in the question of interest of justice and equity. After that, the advocate of the plaintiff need to sign. They have to definitely sign. And after that, we have to write the verification of the parties. Verification plays multiple roles. That is, the parties have read the pleadings, whatever we have told above, and they are telling whatever is there is true and correct. To the parties are confirming the informations are correct. And then after that, whoever the plaintiff will sign that particular document. So once so much is done, then part of your pleadings are complete. And for this, again, important aspect is facts of the case. Try to put as much as facts which you think will help you and to establish. And next important aspect is, when you're narrating your facts, also see what are the supporting documents you will be able to give to the court to establish that what I'm telling is correct. And this is a supporting document which I have to prove my particular case of facts what I've narrated. So this also we need to keep in the mind while we are drafting a particular pleadings. And this is very important. And once you draft 4 or 5 plains, you will get a hangover, and then we start having a template which we will create. So mandatory clauses are already there in the template, but it's our duty to always cross check that we have not deleted or we are overwriting or something. So these are important aspects of pleadings. The next pleading, which is very important, is written statement. So this is covered under Order 8 of the Civil Procedure Code. So what is written statement? It's a defense statement of the defendant. Like how the plaintiff has told what problem they are facing, and this is a relief. The court gives an opportunity to the defendant to defend their particular case by telling what the facts, what they have to tell before the court. So the court have to decide only after hearing both the parties and seeing both the parties' documents. So written statement is a defense statement of the defendant. So seeing that, so what are the main important principles while drafting written statement is, there are only 5 principles which we have to use. One is, while drafting written statement, you need to read very clearly each pleadings which was there in the plaint. So that to see whether this is correct, should I accept, should I deny? So what are the principles are? Acceptance, denial, partial acceptance, partial denial. If you can add more and more grounds to that, what you want to tell from as part of defendant, you can add more grounds, and mere denials. So these are 6 important principles while drafting your written statement, which you need to keep in mind. So when we are reading line by line, we need to apply this particular portion of our principles in each line. Should I accept this? Should I not accept this? Half should I accept, half should I reject? Or should I put more and more facts in that particular place, or should I tell no, merely I have nothing to tell, strict proof? So these 6 principles we have to apply to each paragraph, and that's why I told numbering is very important. Para wise rebuttals are given in written statement. By chance, if we miss something while we are drafting a written statement, there is always a presumption that it is deemed acceptance. If though the defendant has not replied to this particular paragraph, which means they've accepted what the plaintiff is told. So be very careful. More than drafting a plaint, we need to be very careful while we are drafting a written statement. But however, plaint or written statement, the most important thing is whatever we want to tell it in the first instance. Don't wait. I will file applications later. I will file that later, this later. What you have information which you think I should provide at the first instance itself, it is important we provide it in the plaint and the written statement itself. So this even written statement divide, as I told, it that also has cost title. Then the heading goes under order 8, rule 1 or whatever of civil procedure code 1908, and then the defendant submits of what use these principles which I told in each point paragraphs, and then move on to your prayer. And after moving on to the prayer, then verification of the defendant is also must. So the 6 parts which I told you, it is applicable to plaint as well as it's applicable to written statement. And after that, once you put everything, see whether you have structured is correct, whether your document should be arranged logically, whether it is arranged chronologically and divided into numbered and paragraphed very correctly. And then you see whether your language is correct, whether you have avoid all unnecessary and technical jargons in any of your legal documents, and ensure all the essential informations are included in the documents. And then, because otherwise, it's again time consuming. You have to amend and so many other things. So these are the important factors which you have to keep in your legal, specifically pleadings. The rest, all once you know you to draft a plaint perfectly, sure we will be able to draft any documents, writ petitions, or any other documents very clearly once we know the pattern of drafting. And then the general tips are: do not plead evidence, as I already told you, but don't plead evidence. And then be direct and concise. And then check for completeness, that every essential information I have given, I have not omitted any information which is essential and I have not omitted. And use appropriate legal terms. Ensure accuracy in terminologies. Without knowing the meaning or without knowing exactly in that place, should I use that legal term, without knowing, don't use. Otherwise, use with your simple documents. And then be very clear with verifications, signatures, and all the supporting documents which you're putting. After this, we might think page numbers does not play a very important role. We need to also page number each page of our documents from page 1. After the index page, every page should have 1, 2, 3, 4, 5 till the last page of a document. And the list of documents, what all I am giving to prove my particular case, is also very important. That also should have page numbers. So page numbers play a very, very helpful role when we are arguing the case, or when we want to assist the court to clarify certain doubts. If the court asks us or whatever, that helps us to clarify. Suddenly we need not change keeps, so we can tell in this particular page, in this particular paragraph, this is what it is there. And the most important aspect is if you draft a particular pleadings, how many ever year after, without even only one time you have to read, okay, today I'm going for arguments. You can structure what all the client told you, how you had prepared this pleadings so easily if we draft a particular pleadings. That much it helps us to draft a pleading. So these are few of the important aspects. And the next important aspect is always while drafting, the purpose is to transform ideas into a structural and actionable form in a legal format. And then it serves as a bridge between the initial ideas and a final professional concrete format. It tries to bridge the gap. So once this is done, your legal documentation is complete. Most of the myths what we carry with us is drafting is very difficult, and then I can't draft like how you draft, and I can't put things in a very systematic manner. These are all myths only. Any person, any common person or any advocate, it can also, student or anyone can also do wonderful drafts. Only thing we should have patience to hear and patience to put things in a systematic manner. And everything, it does not happen fast. It does not happen how fast we try to do things, does not happen. But it any person can draft. That confidence, if you try, anyone can draft any document. The next important aspect is your structured facts of the case. How do you put your facts of the case while you're drafting? We always represent the parties. So when we are representing the parties' facts of the case, we need to write it in the, like, just for an example, if I'm going to write about a matrimonial dispute, I will tell I got married, I had kids, I had this, I had problem with someone, and then I'm moving out, I want a divorce. So only if you give so much information, it will not suffice the purpose. You need to give, even before marriage, how did your marriage take place? What is it? Was it was a love marriage, arranged marriage, with its elders who organized your marriage, who spent for the marriage, when did the marriage take place, where did the marriage take place, subsequently where did you stay, with whom did you stay? So you should bring that information. So this information is the information which I was trying to tell about chronology of events. So for any narrating of a facts, chronology of events should always be kept in the mind, which is very essential. Oh, sorry, I went into mute. I'm sorry. Now, the next important aspect is drafting of any other legal documents. Now, moving on from pleadings, I'll just come and cover conveyancing documents. See what happens when we are drafting conveyancing documents. What is conveyancing? Conveyancing documents are nothing but transferring of one person's right, ownership, possession, or any other particular title from one person to another person is called as conveyancing of documents. This can be in the form of sale deed, agreements, it can be mortgage deed, lease deed. What happens in all these is possession might be with one person, the ownership is of someone else, title belongs to someone else, possession is someone else, and ownership is of someone else. So these things, when you transfer from one person to another, it is called as conveyancing documents. So for any drafting person, drafting of a conveyancing documents also play a very, very important role, because when we draft a conveyancing document, if there is ambiguity, which will create a lot of trouble later, which then finally it will end up in pleadings and will end up in the court. So it is always important when any conveyancing documents, title documents, or anything when you're drafting, be very clear that it does not have any ambiguity for a long term. And always think when we are drafting a long term period. Don't keep, okay, my client came today, I'm drafting for them today, and then I finish my work. Don't have that in mind. Always keep, while drafting things, for a future, at least for under 30 years or 40 years, lifelong actually, my client should not have any problem with my draftings. So that should be the intention while we are drafting our conveyancing documents as well. Like for example, when I'm drafting a sale deed, or when I'm drafting a will or a gift deed, anything what I'm drafting should be very clear that I'm doing it for my clients so that their lifelong they will be happy, so that this will not come to the court in any other roundabout manner, and then finally the parties are not able to enjoy whatever they have hard earned, purchased, or they have sold, or whatever they can't even enjoy. So that is why the pleadings and conveyancing, drafting of a document of pleading and conveyancing is very important for us to keep all these in mind, so that the person, the ultimate beneficiary is the client. So the client is benefited from our draftings. So it is not to create more and more litigations and more time, energy, money of the client and the advocate and the court is wasted. So to keep that in mind, I'll just give you, I will explain the plaint. I will also explain one of the conveyancing documents. Like the most important document is while we are drafting a sale deed. Very important aspects, what we need to keep in mind. When we are drafting a sale deed, first important thing is when it was executed is very essential. Where it was executed is very essential. Not only in sale deed, in any of the conveyancing documents, where it was executed is very essential. Then, who is the person who is selling the particular document? First party. Then the person who is purchasing the document, their information is very important to be given. And then after that, how did the title come to this particular seller? Whether it was an ancestral property, whether it's partition, whether it's self-acquired property, which number of purchaser he is. So how did the property come? So that you need to narrate in the sale deed very clearly, so that to tell that the present owner from whom I am going to purchase this particular document is legally having all the right to transfer this document to the other person. So we need to keep that. So that chronology of transfer of property from one person to another, might be this is very old property and I am buying in the year of 2026. So from 26 to, we need to see back and see whether titles have come very clearly, and whether my hard earned money, when I'm going to purchase a property tomorrow, I don't want to go and sit in the court. So I need to see whether that transfer has happened legally and correctly. So that's very important. We need to do that particular part. And then the next important aspect is we need to write about the consideration in a sale deed. What is the agreed amount? On the date of sale deed, the entire consideration amount should be paid. And what is the consideration amount? What is agreed by the parties? And the mode of payment of the consideration is also very essential. Whether it is paid through DD, whether it's paid through check, whether it is paid through RTGS, cash, or what the mode of paying. And then the other thing is that from today, you become the absolute owner of the property. The purchaser becomes the absolute owner of the property. So the property is free from all encumbrances, all liens, or any other. There's no mortgage or there's no any case against this property. This property, I am the absolute owner. With all my will, I have sold this particular property to you. So there are certain essential terms which should be in the sale deed. So like this, when we are drafting a conveyancing documents, it is important that we don't miss out main things. Because conveyancing, you just put one word, Google sale deed in Google. Google will give you till that last it will give you formats. So but each formats are different. So what important aspect what we can do is, please prepare individual templates for ourselves, so that okay, when I'm drafting a sale deed, all these points should be covered, and then I put whatever according to my client's need, I put informations. So the template, keep modifying. Don't keep one template which is old, and then keep working on that even after so many other developments come. Revise, repeat your template at least 2 3 months once, or okay, if you don't have time, at least when we have court vacations, 6 months once, please revise your templates each time. See what new is added, what how the law has changed. Should I add something new in this part my template? So you keep it templates for all your conveyancing documents, and this template will help us to template is we have created the template by looking into doing research of various other, comparing number of templates, what is required. Okay, this is required term, this is indemnity is required, other aspects are required. So we keep putting that, and then we fill in the information. What is required, we keep. What is not required, we just remove that particular aspects. So, but however, the templates for conveyancing documents really help us for fast and speedy action on conveyancing documents. So this is particularly with regard to conveyancing. But for both, whether we are drafting a legal document pleadings or whether we are drafting a conveyancing documents, drafting plays a more important role. So that, remember, we are doing this one to the court. So the judge should understand what we are writing in the way we are writing, even after a number of years. And here the conveyancing is for a common man to whom we are helping them to transfer a particular property, movable or immovable, in different forms, so that the person is able to understand what we are trying to write, and then the person, it is actually meant what we are writing. So keep your drafts very simple. Don't keep drafts technically too heavy. And as I already told, drafting is not something very, very, very difficult. Any person, if we put little efforts, can do wonderful drafts. And we can also tell, okay, I also know to draft well. With that confidence, any person can draft. So these are the few important factors. So should I, sir, if any questions, then I can.
Yes, ma'am. You have explained in such a nice manner that how we have to draft in a particular manner of a plain written statement. And the most wonderful part, that which we normally understand as a lawyer, that how we have to make it case, that is keep it short and simple. We'll just check out as to whether we have any questions. So like a lot of people have a challenge, like we have all discussed, how to use the particular sections and the provisions of the Act to facilitate the understanding of the drafting. Whether it should be incorporated, how do you go about it? Or the interplay of the sections and the judgments. Hello?
Sir, actually, when we are drafting, we need not write in a plaint or anything about any sections, or we need not write about any judgments. We even, for example, writ petitions also, we need not write about, already there is a landmark judgment. We need not at all write that. But however, before drafting, we have to know according to which act, what section this talks about. So you have to know under which act, like for example, if I'm going to challenge a sale deed, then what are the essential components for it? I should know Transfer of Property Act. If I'm going to vacate a tenant, if I'm going to file that particular, I need to know the Rent Control Act and the rights of a tenant and landlord. So I need to know those laws well, but I need not write about that in my pleadings.
Yeah. One is, what is the best way to bring clarity without oversimplifying? How to bring clarity without oversimplifying the complex legal issues?
See, the simplicity of language is, if I understand your question, you're telling without complicating the legal
Yes.
issues.
Sometimes we use so many legal jargon. Sometimes the judge also feels difficulty of understanding a particular word, that it can be in a simple manner.
So what happens, when we are drafting a particular thing, it's important, as I told, don't use any complicated big English words or any legal jargons, like any legal words. Without even using that, you can draft a simple draft. And then with anything what you're telling, where you have a doubt, stop it there, pause it there, go check your dictionary, legal dictionary, or any English dictionary, whether this word is making sense in that particular paragraph. And then if it is not what you are intending to write there, please delete that particular point. If you think that helps, okay, what I'm trying to convey is this, and put it. And as rightly told, sometimes it is not, judges are also human beings. Sometimes they also find it difficult to understand. They also have to take legal dictionary and things and verify. And but how I am interpreting might not be how you will interpret that particular word. So it's important you don't write lot of legal words in any of your pleadings. Keep it as simple as you are writing, with only facts of the case. Solely plead facts. Don't plead law. You can talk about law in multiple other places, instances, in evidence. You can talk in your cross, in your arguments. Number of places we have time to talk about legal things. But in pleadings, keep it simple. Don't put any of your difficult legal language.
Yeah. So it says that as a young lawyer, one should try to master the language first, or legal reasoning, or both.
Both. Legal reasoning you should be aware of, then go into simple language of drafting. Because one important aspect is many of us will not know all the laws. We will not know, but when a client comes to us and when tells this is my problem, this is what we want to go to court, when you know, okay, this is the purpose for whom I'm going to the court, then you know from for which court you're going to go. Please read that particular law and make yourself first aware, and then start your drafting process.
One is normally what is dwelling in the minds of everyone. Do you feel that AI will help in the drafting, or how to maintain the check and balance in between the AI and the normal drafting?
So, to be very honest, Chat GPT we also tried using. It is not that we did not try using, but what happens? Chat GPT for legal, specifically for legal drafting, it might help you give your all the facts, everything. It puts in a very structured manner, but it don't rely upon the case laws which it gives at all, because it searches for judgment according to its what it will try to help you by creating false cases, and it will when we are reading a judgment, we need to read it in a holistic manner. What it will do, only pick one word and tell, oh, this case is applicable to you. So please don't use chat GPTs for judgment. Might be if you give good prompts, you might get always cross check whatever information AI and other your Gramini and everything gives you. Please check, double check on all these judgments, whether it's existing or not, and then use it. And the second important aspect of chat GPT for drafting, if you ask, yes, definitely it helps. It is not that it does not help. We nowadays we need not even type. We have to just click the audio and you need to tell I am for this. This is the facts. Please put all the contents what I told you in a structured manner. It will put it for you in a structured manner. Read 2 times of where any gap is there or any information gaps are there. It will definitely help. It is not that it does not help. It helps, but don't use only for judgments and things like that.
That's true. So thank you, Dr. Vidya. I am quite sure that a lot of youngsters will have a lot of brownie points to understand for the pleadings. Thank you once again. Stay connected. We will do more sessions. Namaskar.
Thank you very much. Thank you.